In this video, Judge Stephanie Boyd handles two separate cases that highlight the balance between strict legal procedure and the realities of rehabilitation. The first case involves a theft charge where the defendant attempts to enter a no contest plea, but complications arise when the defense modifies key sections of the sworn paperwork. The judge carefully reviews the situation and refuses to accept the plea in its current form, making it clear that legal documents must be completed accurately and without selective omissions. She explains that by removing acknowledgement of evidence while still pleading no contest, the process becomes legally inconsistent. As a result, she requires the paperwork to be redone properly before the case can move forward, reinforcing the importance of following correct procedure in every step of the legal process. The second case involves a defendant charged with possession of a controlled substance. Here, the tone shifts from procedural correction to sentencing and rehabilitation. After reviewing the defendant's background and substance abuse history, the judge presents a structured sentencing option that includes both incarceration and long-term probation with treatment requirements. She emphasizes accountability while also offering a path toward recovery through supervised programs and rehabilitation support. The conditions are strict, including custody until placement in a treatment facility, but the underlying focus remains on preventing future harm and encouraging personal change. Throughout both cases, the judge maintains a firm but measured approach, ensuring that rules are followed while also acknowledging the human factors behind each situation. The video ultimately highlights how serious charges are handled through both legal precision and structured opportunities for reform, depending on the circumstances of each individual case.
That's her name, correct?
The case was originally submitted as Jan Hawkins.
Okay, but shouldn't Jan Hawkins be the AKA and not Jan Madura?
I think as long as they're both there, it's okay, is my understanding.
Okay. Because all of the other paperwork doesn't have an AKA listed.
We don't have any objection to that, Judge.
All right. We're back on the record. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
And are you Jan Madura?
Yes, Your Honor.
All right. And you're not Jan Hawkins, correct?
No, Your Honor, I'm Jan Madura.
Oh, thank you. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are waiving count 1. We're proceeding on a lesser included of count 2.
And what are you proceeding on?
On a Class A theft.
No objections, Your Honor.
All right. Did you review the court admonishments with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it in electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand the state is proceeding on the lesser included offense of theft, $750 up to $2,500 as a Class A misdemeanor? Range of punishment is anywhere, it's up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea you are giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Miss Madura, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Did you understand by entering this plea, if you're not a U.S. citizen, you will be deported, denied naturalization, and the right to re-enter the United States?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense under count 2 of theft, $750 to $2,500. They're waiving count 1. They are recommending deferred adjudication. They say that you've paid $1,077.01 to the Junior League of San Antonio. And I'm assuming there are no other outstanding restitutions.
There's one that we've got on there below the line, Your Honor. There was an insurance claim that was made by the complainant by Berkshire Hathaway. It's reflected toward the bottom.
All right. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Your Honor, we understand that we can address the court on the any restitution to third parties, but yes, other than that, it is our agreement.
State, is that the plea?
That's the plea, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes,
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. They're recommending restitution to Berkshire Hathaway in the amount of $9,799.42 and $227.71 to Visa. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes,
Then to the offense, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
no contest.
State any evidence.
We'll offer Exhibit 1 with all attachments.
No objections, Your Honor.
Right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, that means that the state will be presenting witnesses in the form of witnesses' statements and police reports, but there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations.
Your Honor, if I may, we did make an amendment to the stipulations in concert for agreement with the ADA. We have marked out we're not saying that all the stipulations are true and correct. We have a controversy on the amount, the final amount. So
I think the issue, Judge, is that if you're intending to impose the restitution to Berkshire Hathaway and Visa, they're going to ask for a restitution hearing. Is the main issue here?
Well, I am going to ask to a restitution hearing.
Okay.
And the fact, these stipulations, you can't just cross out that you're not stipulating that the evidence is true and correct because you haven't stipulated which party you're saying is not correct. When you cross out the stipulations, then you're saying we're not stipulating to any of it. So you all will have to correct your paperwork.
Judge, if I may,
Mhm.
we've done this before. We are
Not
pleading
with
no.
me.
Actually, I have on one prior plea on a case that was a family violence case, Judge, in this court. But we are pleading no contest, which means we don't necessarily agree, but we're not fighting about it, which is provide purpose having us do. We've also marked out judicial confession and changed it to no contest.
Oh, you can change all of that to no contest, but you can't change what you're stipulating to because otherwise she's not even stipulating to the fact that she owed $1,000 to the Junior League.
Well, Judge, she doesn't have to stipulate to it. She's pleading no contest. And so that is the plea that's provided in order for people who disagree with what's being said to be able to move forward with a plea. I've never had a problem with that before. I've done it in this court.
No, I tell you what has been done. There has been with regards to the indictment that's a part of it where you say, I am not contesting anything and you take out the judicial confession, but the evidence is the evidence that is presented. And then the court makes a ruling on whether or not that evidence is sufficient from the Junior League.
I think we've got a clean copy of the paperwork, Judge, that we can.
All right.
Judge,
swap out.
if I may, we can't stipulate to the amount. So we would have at the very
That's why you have it. Nobody ever stipulates to an amount. That's why you all have contested hearings and I make a decision on whether or not they owe it or not.
and Judge, and I know we're getting in sort of ahead of ourselves, but I'm I'm asking for the court to not order restitution to the third parties. I don't think that that's appropriate.
Well,
They
that's
have-
where you present evidence and I make a decision, or you present some kind of law and I make a decision on whether or not that amount that is below the line, because it's not a part of your agreement, then I make a decision on whether or not that amount should be paid or any amount should be paid to Visa or Berkshire.
And Your Honor, it's what I'm requesting the court to do is to not order that, so that can be handled in a civil court. They are set up for that. That's the way the normal course goes on these things, and it's going to be. We would need a forensic accountant to go through this. It's going to be a very long and arduous restitution.
I understand what everybody is saying. I want to let everybody know I'm internalizing what's being said. What I am telling the parties is this. If she's not stipulating to the evidence that's been presented by the state, that means she's not stipulating that she even committed a theft with the junior league. I don't know why she paid the amount to the junior league, because she's not stipulating to that. Things that are below the line, that means that it's contested. That means that I'll hear evidence. I'll make a decision on whether or not restitution should be paid to Berkshire or Visa. That's something that I would hear. The only thing you're allowed to do, I don't contest, is when they have in the plea paperwork where it has the indictment on or about whatever. That's like on or about whatever. I judicially admit. You can scratch that out and you put, I'm not contesting anything. But for the stipulated evidence, the evidence is what's being presented. Otherwise, if you're not stipulating to any of the evidence, then there's no plea.
Judge, we're willing to stipulate to everything except the final
Then
amount.
you all need to change your paper.
And Your Honor, I know, to press a point on this, it's my understanding, my belief that the law allows us to not stipulate to true and correct. The judge has the evidence, and the judge can look at that and decide that they find those documents credible and find that they are true.
I can't do any of that if y'all are not stipulating to anything. Then everything is a challenge. So this is what I will tell y'all to make it simple. I'm not accepting this plea.
Okay, we'll redo the paperwork. Would you accept if we just simply put on that we do not stipulate to the final amount?
Y'all do the paperwork, and if y'all want to put in there that the final amount from Berkshire and Visa is contested, which to me, you've already said that. That's why it's below the line. If y'all want to do that, fine. But everything else, no.
And you understand that all the money was for the junior league, but they just filed an insurance claim and a Visa claim.
Here's the thing. I haven't read any of the evidence, so I don't know what y'all are presenting because y'all haven't stipulated to anything. I don't know why there's an objection to outside the agreement. Everything that is outside your agreement is contested, and I'll hear evidence. This argument that you all are making on she doesn't owe to Berkshire, she doesn't owe to Visa, we haven't even got to that point yet because nobody's stipulated to anything. And when things are below that line, that means that it's contested. That means I'll hear arguments. I'll hear whatever kind of law somebody wants to present me on whether or not you should be paying that under this cause number.
And Judge, the reason I am making this issue is because it says in the documents that higher amount. So we don't want to stipulate to that. So we'll change the document to say that and we'll reapproach.
Oh, y'all need to reprint that entire document out because that's been sworn to. She's been sworn to that specific document by the clerk. And if people start making changes to that document, it's no longer a sworn document.
We can do that, Judge.
Okay.
Thank you.
R015632, State versus Christopher Polito. Could I have parties announced?
Derek comes from Mr. Polito.
And are you Mr. Polito? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Polito, did you review the application for community supervision with your attorney? Did you understand it? And did you sign it? Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Polito, did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1 to 4 grams. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years into prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. All right. Counsel, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Polito, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 6 years in the prison. There's a $1,200 fine, and the state is opposed to your application. Did you understand that to be the plea?
Yes.
Defense?
It is, Your Honor.
State?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motion?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Yes, Your Honor, she offered states if we got it all.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find that there is sufficient evidence to find you guilty, and the court will find you guilty. What is his criminal history?
State theft as well as conviction for burglary of ability and possession E11 two felonies were referred to.
Okay. All right. Are you waiving PSI?
We can. The state's opposed, but we can.
Well, no, my question is, are you waiving PSI?
You want the judge to make the decision, then you want to wait 30 days.
I'm going to make a decision.
We'd waive the PSI, Judge.
All right. And state your opposed, and why are you opposed?
From this judge, we are opposed. Mr. Polito was placed on probation in 2023, as well as that drug conviction in 2023, and then picked up this new case. So he's already done a trip to TTC on that 1 grams of heroin.
All right. Thank you. So why were you revoked on your last probation? What did you not?
In conclusion, this video brings together two very different courtroom situations that both reflect the seriousness of legal decision-making and the responsibility placed on the judge to ensure fairness and accuracy. In the first case, the focus is on procedural correctness, where even small changes in legal paperwork create major issues in how a plea can be accepted. The judge makes it clear that legal processes cannot be adjusted or simplified in ways that compromise truth or consistency. Her decision to pause and require proper documentation reinforces the idea that every detail in a case matters, and shortcuts in procedure are not acceptable in a system built on structure and accountability. In the second case, the focus shifts from procedure to sentencing and rehabilitation. Here, the judge carefully evaluates the defendant's background and circumstances before presenting structured sentencing options that include both punishment and the opportunity for treatment. The emphasis is placed not only on consequences for the offense but also on the possibility of personal change through supervised programs and long-term support. This approach shows an effort to balance strict consequences with a path toward recovery, especially in cases involving substance-related issues. Overall, the video highlights how different cases require different forms of judicial response, ranging from strict enforcement of rules to carefully designed rehabilitation plans. It reflects a justice process that is both firm and thoughtful, ensuring that accountability is maintained while still recognizing opportunities for improvement and change in appropriate situations.